Who are you? And where are you going? What do you want?
Hello and welcome to Trusts and Estates Weekly. I'm your host, Kevin Bemmel, and we're here every Monday at 10 a.m. Pacific time to talk about estate planning and trust and estate administration, both from the standpoint of professionals like my guest, Andrew Nutbrown, and me, but also for individuals who are faced with this particular financial challenge. Always good to sort of peek in and get some thoughts about what has to happen in order to make sure that our own our own estate plan is put together and we're taking care of ourselves. Which it always brings up the cliche of the estate planning lawyer who has no trust, has no will, right? Typical thing. So we're going to try and avoid that. So as I mentioned just a moment ago, I'm really pleased to have as my guest today Andrew Nutbrown. So Andrew is an estate planning and estate administration attorney here in the Los Angeles area. You're based up in Pasadena, right?
Yep, that's right.
Yeah, and you will sense right away that Andrew speaks with a little bit of an accent. That's because he comes from the land of, this is the only Canadian thing I know, the land of twofers, which I'm told refers to a 24 pack of beer, which is, I guess, how Canadians buy beer. So now you know the full extent of my knowledge of Canada, other than Montreal is an extraordinarily beautiful city. And I loved every minute that I spent there, these many years ago. So, and Andrew is going to be talking about cross-border estate issues, which I think is a topic we haven't covered here on the show yet. So Andrew, welcome to Trust and Estates Weekly. Thanks for joining the show.
Thank you for the invitation. Appreciate it.
Yeah. So start out, if you would, just so viewers can get to know a little bit about you. How did you get involved in estate trust and estate law, and why? Give us a little bit of background.
Yeah. So originally, my background was fully in Ontario. So I grew up in rural Ontario, Canada. And initially I went to law school thinking I was going to be a Crown attorney or a prosecutor. And during my time at law school, I volunteered. They had a legal clinic in the law school. And so I did some criminal defense work there. And I was exposed to what I perceived to be issues in how the prosecution was dealing with disclosure issues, how they were prosecuting cases that didn't really seem to make sense to me. Like my first trial was actually, I know we're going off on a little bit of a tangent, but my first trial was a case where there was clear video evidence proving that they weren't guilty. And even though we forwarded that information to the prosecutor, they didn't drop the charge, and then it went all the way up to a trial. And then one of the key witnesses, who of course was caught in a lie in that case, didn't show up, and then the charge was dropped. But it was just a complete waste of time. The client was a nervous wreck. It could have had a dramatic impact on their life.
Right.
And so that kind of turned me off from that practice. And when I was at the clinic, it was a bit of a unique legal clinic at the law school, because there were we did civil litigation cases up to a certain level, criminal cases, landlord-tenant issues, and then we actually did wills and estates cases as well.
Oh, wow.
And normally it was for people who didn't have large estates. And I remember my first will being done, and it was for someone who was terminally ill. And so we did the documents really quickly, and it provided a lot of dignity for them. And it also allowed for a smooth transition when that person passed. And so for some reason, that's where I found it really fascinating. I found like the work had a lot of impact and value
Mm-hmm.
on people, and then after that first client, I did a lot of wills actually when I was in law school during my time at the clinic. So that was around a 2-year period,
Mm-hmm.
and I think just generally, I always expected that I would be, the town lawyer close to where I grew up.
Uh-huh.
So I ended up after law school. I got a few different job offers. One of them was in a fairly small firm. It was, I think, 6 or 7 lawyers down in Leamington, in Kingsville. They had 2 offices down there, which is basically the southern tip of Ontario, right close to the U.S. border.
Uh-huh.
So that was my first time seeing, I guess, more larger scale estate plans, how those were done from the Canadian perspective usually, and then a little bit of a cross-border element. A lot of our clients had U.S. assets. I remember, I think my first cross-border case was actually from Trinidad at the time, and there was just a lot of practical issues beyond just the complicated legal issues that tend to arise.
Mm-hmm.
From there, I was a lawyer close to where I grew up. At the time, my fiance was still in London, Ontario, and it was a bit of a drive, so I moved back closer to home. And then ultimately, I moved down to California for my wife's career initially.
Mm-hmm.
And when I moved down, I wanted to be able to use my Canadian license and experience from the last 4 or 5 years. And so I looked up a cross-border international estate planning lawyer that was nearby. Kevin Moore, our managing partner, turned up. I cold called him, and the next thing I know, I'm working in Pasadena doing US and then at times Canadian estate planning as well.
Wow. I mean, and it's a great story, I think it's what I find is a lot of the people who ended up in the estate planning, estate administration realm, they actually have sort of a different background. It wasn't what they intended to do. They didn't, grow up as a kid going, I want to do wills and trusts. There's something else, but then that's very much the case with me. In my real estate practice, what I found was I thought the work that I did that was among the most valuable was the work I was doing, as we were talking before the show started, for Jewish Family Services conservatorship program, where I felt like I was really helping to solve problems people had, as opposed to just, helping people make a lot of money because they own this property. Nothing wrong with that, but there's sort of more meat on the bone when it comes to helping people really solve some difficult problems.
It's the best area of practice because you can be creative. I would say compared to other practice areas, you're doing more, meat and bones law work.
Mm-hmm.
But you have to understand and deal with family law issues, corporate issues, real estate law issues, and then all of that intertwined. You get very interesting personal dynamics, and it's a blast. I couldn't imagine myself doing anything different now.
Yeah. Same. I mean, I marry my background in real estate. I was a law clerk when I first got out of college, and I was a chaplain. So, all of that works together really well for being what I do, a professional fiduciary, because there's a whole emotional component to our work as well, as I've mentioned a few times on the show.
Yeah.
So let's get to the topic now, which is cross-border estate issues. So you mentioned that a lot of your work, at least in the beginning, was cross-border Canada, U.S. What do you see as being the most common cross-border issues with which you have to deal, and why are those? Do you think those come up, so frequently?
So there's a lot of Canadians in general down in California. The snowbirds like it down here. So I think I see it commonly in 2 different forms. either a U.S. person that lives down here, is a U.S. citizen, and has either like a cottage or some assets in Canada.
Mm-hmm.
And then the second is a Canadian resident or Canadian citizen, and then they have like a vacation home in California, or they just have assets generally in the US. So those are the two, I would say, most common types of scenarios, and they have very unique issues and different issues. So, for instance, and then I would say maybe a third one would be their parents or grandparents are in Canada, and they're now living in the US, and they're expecting to inherit a lot of assets from Canada. And so they reach out because they want to see, okay, how can this best be done?
Right.
And similar scenarios in other countries as well, but for Canada, those are the kind of the three things I see.
Mm-hmm.
And it gets really interesting because then you get presented with a unique puzzle that you have to try to make fit. And I always describe it as, in Canada, you've got circular pieces. In the US, you have square pieces, and you have to just make the best puzzle you can in that circumstance.
It's interesting because I realized as you were talking just now, I have a long-standing friend, originally from Canada, British Columbia to be specific, and this is now going back, I think, about 3-4 years ago. About 3 years ago. Her father had passed away. He lived in Canada. She'd been a long-time resident here in Los Angeles, had a business career here and everything, and I think she had become a U.S. citizen. And her father had left behind a house in British Columbia, right? But he also had a house in Arizona,
Yeah.
And, the going back and forth and dealing with it all, it was really kind of frazzling her nerves, right? Along with, of course, she was the only child. So that, again, her mother had passed away many years before, but now her father, to whom she was very close, had died, and it was just the whole emotional burden of it was very, very difficult. So,
Right. Yeah. So, like in that circumstance, if they're living down here, like Canada, generally tax based on residency. So, and so in that situation, the only asset in Canada that would get hit on after passing would be the assets situated in Canada and located in Canada, like the real property and or stocks and bonds or shares in Canadian corporations that hold real property.
Mm-hmm.
And so because of that, like in Canada, there's no estate tax like there is in the US. But instead, all of the assets that are subject to, in this case, all the assets located in Canada, are deemed to be disposed of at fair market value. So you get triggered a capital gain. And so that's how most estates are taxed.
Mm-hmm.
There's very few exceptions to this. And so in this scenario, there wouldn't really be an exception that would apply. And so you're, in that case, you're probably paying a tax in Canada after passing. But in the US, you have a step up in capital gains. If the assets are below the exclusion amount and you're a US citizen or US domicile, then right now you've got almost $14 million of exclusion. So you're probably not paying anything on the US side. So the Canadian side is harder to deal with on that.
Yeah. So I want to make sure I understand. So I don't know what the house in BC was worth, but let's just say, for the sake of argument, the house was worth $2 million. So the house, whether it's actually sold or not, is deemed sold. I assume as of date of death.
Yep.
Right. So if the house was acquired for $1 million, there's $1 million gain there. That's taxed as capital gains in Canada. Here in the U.S., unless the gross value of the estate exceeded $14 million, there's no tax due. Now, what if the gross value of the estate, let's say it was a huge estate, let's say it was a $30 million estate, right?
Yep.
So despite having paid capital gains taxes in Canada, the $16 million exceeding the exclusion amount would be taxed here in the United States, no, even though some of the assets are not US based.
That's right. So US taxes worldwide. And so there is a Canada-US estate tax treaty. We're lucky because there's not that many countries that actually have these. And so you can take credits for the Canadian capital gains tax that was paid. So you can use that on the US estate tax return.
Mm-hmm.
I would say the benefits of that treaty come up more often on the reverse scenario where you are a Canadian resident and you have U.S. assets, because normally it's very severe. Where if you're a non-resident alien, so you're not a U.S. citizen or U.S. domicile,
Mm-hmm.
You have an exclusion amount instead of $14 million of $60,000. So
Wow.
you pretty much have no exclusion at that point, especially
Right.
if you're looking at California, where an average house is usually over $1 million at least.
Mm-hmm.
So if you had a $2 million house in Malibu and you're from Canada, absent that treaty, you would get hit with an estate tax of several $100,000, probably around 700,000 or so if it was 2 million.
Mm-hmm.
But what the way the Canada-US treaty operates is that you get essentially the same form of exclusion worldwide, and then you take the percentage or a fraction of the worldwide estates that are located of the worldwide estate that's located or situated in the U.S.
Mm-hmm.
And then that fraction is then multiplied against the then current exclusion amount. So then you get a smaller U.S. exclusion. So if you had, let's say, double your Canadian assets or double the value of your U.S. assets, then you would have half the U.S. exclusion. So you'd have a $7 million roughly exclusion in the U.S. And then that would be applied. So then it's not adversely really hitting the Canadian. So we're pretty lucky, because if you're in Mexico, let's say, or Brazil that doesn't have an estate tax treaty, you're paying that estate tax. And then so when those issues arise, like on the planning side, it's really important to do something before it's too late.
Right.
And the focus is normally on changing the landscape of the client's assets, so they're not considered as owning or holding U.S. situs property or property situated in the U.S. So if there was a vacation home, for instance, and normally we have to work with a bit of a team on this because we don't want to cause any issues in their home country or any income tax issues.
Mm-hmm.
But often the focus is on putting the real property into an entity and then having the foreign entity, it might be from their home country or a different country, hold the shares or the interest in that U.S. entity. And that way, when they pass away, their estate isn't the real property itself, it's the shares or interest in that foreign entity. And so you're not exposed to the U.S. estate tax. The hardest puzzle to unwind or to fit together on this is the income tax issues that are associated with that. And so normally we're working with CPAs to define, okay, the estate tax issue is a big issue. How do we deal with that in a way that isn't income tax prohibitive? Because if you're having, a foreign entity and then you're holding an interest in a U.S. entity, if you're doing it like that, you'd be paying the income tax on the U.S. side, and then you're paying the income tax again when you get. So that's the harder part. If it's a vacation home that's not making too much income in the first place, then it might not be as significant of an issue.
Mm-hmm.
But yeah, so that's that. In Canada, we don't necessarily have to do that for most clients. You might still want to do it if you're above the exclusion amount because you want to avoid having to pay the U.S. Estate tax upon their passing, even though it might be, relatively small.
Mm-hmm.
So, yeah.
I mean, yeah, I think I'm following. So let's take something other than a vacation house. Let's take a business that's here in the U.S. And a Canadian citizen has a share in that business. They could own it directly. In other words, it could be let's say in a U.S. corporation, they own shares, or they could form, let's say, a Canadian, I don't know if Canada has LLCs, but a Canadian LLC that then owns the shares of stock in the U.S. corporation, and that sort of domesticates what is otherwise the ownership of a foreign business.
Yeah. So, exactly. So you could do something like that. Now, the LLCs is actually a great segue because that's one of the most common issues I see where things aren't really thought out on both sides of the border from the Canada-US side. So LLCs in Canada aren't really recognized in the same way as the US. So an LLC is viewed and treated by Canada as a corporation.
Okay.
And so that causes a problem because in most of the time the LLCs in the US are treated as pour-through entities. So the income is paid by the members of the LLC. But when you are dealing with the Canada-US treaty and you're taking income tax credits on both sides, that's a problem because on the US side, the credit or the deduction, whatever it might be, would be on the individual. But on the Canadian side, it's a different person or different legal person. And so you might not get that credit or deduction. So usually holding LLCs as a Canadian resident is a really bad idea because you might get hit with double taxation.
Right.
The other thing that's an issue are trusts, like revocable trusts. So in the US, the standard cookie cutter estate plan is a revocable living trust.
Right.
A will that's a pour over will that if you pass away and something's not in the trust, it just goes through the trust. And then it's a very smooth transition when someone passes. In Canada, that's a disastrous estate plan because in the US, that revocable trust is considered what's known as a grantor trust, which is a trust that's a pour-through or a see-through entity where the trust creator is considered the owner. So you don't file a separate tax return for your revocable trust, right?
Right.
In Canada, that's not the case. It's treated as a separate taxpayer, and worse, all of the income is taxed at its highest marginal rate. So let's say you've got the client who or the person who's a California resident, U.S. citizen, and they decide I'm going to get a cottage in the Muskokas, which is a very popular vacation spot outside of Toronto. So they buy a cottage and they put it into their revocable trust, just like all of their U.S. assets. So the issue is that when you transfer assets into a trust in Canada, the general rule is there's a deemed disposition. We love deemed dispositions in Canada, so you get capital gain there. When every 21 years, there's another deemed disposition. So you have a capital gain. So those generation skipping trusts that are great in the US, if they're holding Canadian assets, they're not so great. And all of the income, if it's being rented out when it's not being used, is taxed at the highest marginal rate. At the federal level, that's around a third. So and then you've got provincial taxes too. So it's really, really bad in Canada to use those revocable trusts. And there's been some interesting cases starting, I think, back in 2019, but then they started to come up more often in 2022 and on. But a pour over will in a lot of provinces is typically not considered even a valid will. So I've seen that come up on the back end where someone has passed away they have a pour over will, and there's assets located in Canada. And so then it's a challenge of, okay, how do you probate that? How do you get the assets ultimately into the hands of the beneficiaries without having it be an intestacy, basically an estate where you have the general rules of the province apply on how it's divided amongst the heirs. So there's a lot of just apart from the tax issues, there's a lot of issues with trusts, LLCs, assuming something works in another country when it doesn't, and a really sad, might come off as funny issue is where you'll have documents in different countries that aren't really coherent. And I've even had one where the U.S. will, of course, the first line in the will is I revoke all prior wills, and it's governs wherever, like all of my assets wherever situated, and so inadvertently they revoke the Canadian will, and of course the beneficiaries in that particular case were different, so then we had a fight on our hands.
Oh gosh.
So yeah, so you get a lot of interesting stuff that comes up, and it's just really important to make sure that from the perspective of the client that their advisors are talking to each other, that they understand the general rules in each, and from an estate planning the estate planner's perspective, to have, if you're going to have a lot of clients with who have assets in that other country, to have some familiarity with generally how that works, so you can issue spot and then work with the advisors in that other country, so you can have a coherent plan. So it's a fascinating practice area.
Yeah. Well, I'm gonna take a break here for just a minute, because the conversation is fascinating. I've got 2 questions I'm burning to ask.
Sure.
But I want to let everyone know that Trust and Estates Weekly is sponsored by Probate and Trust TV. So this is a new venture. It's a YouTube channel that aggregates all of the best content on estate planning and trust and estate administration in one place. So among the contributors are, of course, yours truly, but also Bill Gross, one of the top probate and estate real estate agents in the United States, and Paul Rabelais, one of the he has the largest YouTube channel on trust and estate issues. Paul is based out of Louisiana. So it's the one place you can go, whether you're a professional like Andrew and me, or whether you're looking for your own basis, to get answers to questions you have about probate and trust matters, and also meet people like Andrew who can help you solve them. So you just go to youtube.com/probate Trust TV. You can see all the content there. So thanks very much to PTTV for sponsoring this show. So now going back to our conversation, this is Probate and Trust TV, Probate and Trust Weekly. My guest is Andrew Nutbrown. Andrew is an estate planning attorney based in Pasadena, California, and he was talking about the complex issues of dealing with an estate that has property in. We've been using the example of Canada and the United States. So Andrew, one of the questions, and this may be kind of a little bit off to the side, but both U.S. and Canadian law, U.S. law is largely based on English common law, especially when it comes to probate and trust matters. And I would think, being a member of the Commonwealth, the same is true of Canada. And yet it appears they've evolved quite differently. I'm just curious, why did that happen? Typically there's some sort of public policies undergirding these things, and evidently very different between Canada and the US.
Yeah, so the common law in Canada and the US for trusts and estates is for the most part very similar in the general application, but the issues that like a lot of the tax issues and like the LLCs and trust issues are based on the country's legislation. So there's a law that's passed by the Canadian government that that provides how trusts are taxed, and so that's driven by their own unique goals of the legislature.
Right. Okay.
And so partly because I think we don't have a U.S. estate tax, we have this other mode of taxation to try to deal with the issue of, okay, how do we tax estates after someone passes away?
Mhm.
And in the U.S. they've come to a different conclusion. And it's interesting. A good example in the Commonwealth that's like that is South Africa, in that they actually South Africa is an interesting country because they've used a lot of the same approach that Canada has on the deemed dispositions,
Mhm.
but they also have an estate and gift tax like they do in the U.S. So it's actually like a combination in a way of the two countries. But there are some unique differences, and part of that is because we've had a different history in the common law than the U.S. has, because as you know, U.S. becomes its own country much longer before Canada has.
Mhm.
So all of the English precedent is binding on Canada up until when the Privy Council in the UK basically severed off. So we're up to around like the 1930s, where we've got rulings in the English High Court and highest court that are binding on Canada. So in many ways, India, for instance, has some rules that are closer to Canada than Canada and the U.S. because we have the courts going on separate paths. Like one example is there's a huge case that's binding in most of the common law, including Canada, and it was an English case called Saunders and Vautier. And what that rule provides is that whenever there's a circumstance where all of the beneficiaries have all of the interests in a trust, they can force the trustee, irrespective of what the trust terms are, to distribute all of the trust assets immediately.
Mm.
In the U.S., they don't have that rule, and so I was aware when I was studying for the bar exam that it didn't look like they had that same Saunders and Vautier rule in it.
Mhm.
But I was working on a trust litigation case, and I thought where you would have been able to use a Saunders-Vautier rule if it was in Canada or in England or elsewhere. And so I looked it up, and it was cited in a California case, I think in like the very early 1900s. And according to that judge, the Saunders and Vautier case did violence against the law. So it's very, very different approach to that issue. And that's standard form. Like every single lawyer estate planning lawyer in Canada should know that rule and how it operates, because you don't want to unintentionally cause that rule to be triggered when your client doesn't want that to be the case after they pass away.
Right.
So yeah, so even though the estate plans look radically different because we're dealing with different tax laws that were passed by the government usually,
Mm-hmm.
And although the common law is very similar, the general rules of how a trust operates, how a will operates in both countries is pretty similar. So like in the US, your general estate plan is a revocable trust, a pour-over will for a moderate size estate. In Canada, for that same asset value, you would actually use something that's a bit unique to Canada, where you would have dual wills. So each person, instead of having a revocable trust, which is not the greatest for income tax purposes,
Mm-hmm.
you would have two wills, and that's to avoid a provincial tax that's applied when assets go through probate.
Mm.
So in most provinces, you don't need a certificate of probate to deal with all of the assets. So if you had certain types of real property or shares in a private company, and that was the only asset you had, then you could have the will, don't have to go through probate, and then you administer it similar to you would like a trust in the U.S. So what we do is we make two wills. One will that's governing only the assets where you need that certificate of probate to administer. And then the second will that deals with all of the other assets that you don't need the certificate for. And then through that, you then severed off all of the assets that don't need that certificate, and then you don't have to pay the estate administration tax, is what it's called, or probate fees. So the biggest one is shares in privately held companies. So in Canada, a lot of estate plans involve these primary and secondary wills and assets held in corporations, which are more income tax efficient than what we're used to in the U.S. And then when someone passes away, the secondary will, the tax-free will, then governs how the assets are divided. So you're only limited to what really you need the certificate for, which are typically relatively large bank accounts, certain types of real property, if they're not held in the corporation already. So.
Wow. I mean, that's very different than how it works here in the U.S. Yeah. So when we think about strategies for dealing with estate taxes, ILETs, and those sort of things, so that too, I imagine, is very different for the Canada side of this equation, and so when you're dealing with both, what do you do in terms of, tax mitigation strategies, either making sure, an estate has sufficient liquidity to pay, the capital gains taxes in Canada, or has liquidity to pay estate taxes here in the US? How does that work? And it seems to me like if you set up an ILET here, I guess, can you even, take that liquidity to Canada to pay, capital gains, et cetera? There's a whole range of issues there.
Yeah. So I think there's a lot of tools, especially on the U.S. side, that can make things much easier. And so, for instance, on the U.S. side, you can have trusts that provide incredible amounts of flexibility after someone passes away. So if you have, let's say, a U.S. person and they've got Canadian beneficiaries, or some of their children are in Canada, you can set up a trust. Often we incorporate trust protector provisions or something of that nature in there, so that if the circumstances on the ground are different at the time of passing, then there might be some ways in which you can make modifications to the trust, change the situs of the trust, so where the trust is resident, and so then you can kind of adapt to how things might change, because although clients should look and review their estate plans every year or every couple of years or so, that doesn't always happen.
Right.
Yeah. So, but for instance, like I've got some clients where their children are thinking, well, I might do school in Korea, for instance. I'll just use an example.
Okay. And
in Korea, from what I understand, because I'm not licensed in Korea, but from what I understand, the taxing authorities there will treat that beneficiary as owning generally all of the assets of the trust. And so if they're resident in Korea, you might have an issue where that beneficiary, if you have like a standard type of provision where their interest is for health, education, maintenance, and support, which is great for on the US side for estate tax planning, the risk is that they might be facing increased taxes in Korea. And so from what I understand, you can, in that circumstance, if the trust is converted before they move, or into an absolute discretionary trust, there might be some arguments that can be made where they're not going to have all of the income of that trust treated as being earned by the resident of that foreign state. So so those types of provisions, a trust protector provision can sometimes include provisions that allow that to be modified when the time comes. Similar on the Canadian side, in Canada we have trust inclusion rules or trust attribution rules. And so part of that is based on where the assets originated from. So if you have a US person that formed a trust, and then there's a Canadian beneficiary that has an interest in the trust, depending on the terms of that trust, Canada might treat it on behalf of the Canadian as if they're the ones earning all of the income. But if the terms are restricted enough and the trust is actually not being administered in Canada, like factually it's being administered in, let's say, Nevada, then you can help avoid a lot of the issues in those for those Canadian beneficiaries. Those 21-year deemed disposition rules, all of those really bad trust tax consequences in Canada, you can try to avoid it by just administering it well and building in flexibility on the U.S. Estate planning side to try to deal with what is often a changing circumstance year by year.
So, we've been talking, or maybe I have, because I'm the novice here. I've been talking like the U.S. is sort of homogenous and Canada is homogenous, and yet we have 50 states plus a couple of territories in the U.S. and trust law and state law is actually more a state by state function. There's no, with the exception of the estate tax provision, which is U.S. It's really state by state. I could imagine it's province by province in Canada as well. What kind of complexities are there to these cross-border issues when you may also be dealing with multi-province, multi-state issues, within these two respective countries? Yeah.
So that's it. That's similar. So the capital gains, all of those, that tax issue, that's Canadian federal law. So that applies no matter which province you're in. But the probate fees or the estate administration tax, that's a provincial law. Now, a lot of the provinces have that, but Alberta, they have very little a tax to the point where it might not be worth making that secondary will like I was describing. Mm-hmm. And then Quebec, of course, has a civil law background because of their French heritage there. Mm-hmm. So that's very, very different than the other provinces. Mm. So there are times where we're working with a lawyer from that specific province to try to deal with the estate planning documents there, even though I'm familiar with the Canadian federal income tax issues. And same with the US. So one of the, I would say, most common things that's California specific are how properties are how property tax works in California and when properties are reassessed. Right. So that's not common in a state like Texas, for instance. So if you have California properties, you might not realize that although your property tax base now is very low, upon passing, there might be a change of control in all of the LLCs you have, and then everything's reassessed at fair market value. It makes the properties much less profitable. And so that's a great example of how you might have, if you were a Texas estate planning lawyer or you're a Texas client and you're dealing with a set of facts that might be treated as if everything is homogenous, but you'll have state by state issues that might require action to be taken to really avoid some pretty brutal consequences in that state. Property tax in California, I think, is the perfect example of that. Yeah. Because, like, one of my favorite clients right now, he's 98 years old, has most of his assets are real properties in Texas and in California. And so you can do some restructuring on the California side to really avoid a lot of those property tax reassessments, which is huge because their property tax base might be, because they've held the properties for so long, like $300,000 when the property's $3 million. That's changing the property tax amount from a couple thousand a year to several tens of thousands a year. So,
Mhm.
yeah.
You know, back when I had my real estate company, I had you reminded me of this. I had a situation where I was sharing an office with one of my clients. It was a father and son. Father passed away, and so the son was administrating his estate. And because of Prop 13, the way uh, um, properties are assessed for taxation is very, very different here in California. And this happened to be at a time when, because of the automatic increase, the 2% automatic increase in assessed value, it had pushed the assessed value of a property much higher
Wow.
than its market value, right? And so, in administrating the estate, the son had the properties appraised, and on one of the properties in particular, the IRS challenged the appraised value, saying, "Well, the assessed value is like 50% higher, right?" And my office mate shows this to me, and I'm like, well, this is ridiculous. I said, I'll write a letter explaining to the auditor how the system works. And I hadn't done the appraisal, if somebody else had done it, but I wrote that letter, and I showed them that there's no relation between the two, except maybe at the time of the sale of a property.
Right.
And to my surprise and my office mate's pleasure, the IRS backed off immediately when they saw what the real situation was.
That's such a coincidence you bring that up. I recently had a IRS audit. Now, it was more focused on gift tax in the US. So when you're dealing with clients that are going to be facing or likely to be facing an estate tax, often a great strategy is to set up one, often several irrevocable trusts during their lifetime that are taxable gifts. And this is one of the great tools in the U.S. side that I don't see a real equivalent on the Canadian side. But you can create a trust that, for income tax purposes, is a grantor trust, like what we discussed earlier.
Mm-hmm.
So it's treated as the owner of all of the assets, but for gift tax purposes and estate tax purposes, is not the same owner. It's a completed gift. So the benefit of that is you can gift assets that are appreciating in value, and you report the gift. It decreases your lifetime exclusion,
Mm-hmm.
and but then all of the appreciations outside of the estate, all of the income from those gifted assets and those trusts can be paid from the portion of your estate that would be subject to income tax. And then so you have a scenario where, had you not done anything, the estate tax would have been much, much longer, like 15, 20 years down the line. So for this client, we were doing a trust like that. We used her principal residence for that trust. There's a different trustee, and then we had a lease agreement. So she's paying rent to the trust that's for the benefit of her kids. And that rent's coming from her taxable side. It's increasing the non-taxable side. All the appreciation's going out, and then so the just by chance the IRS audited it, and so one of the issues was the valuation of the property at the time, and so there was actually a disconnect between what the assessed value was, because the property was originally purchased in, I think, late 2008.
Mm-hmm.
And then, of course, so around that time, the property values actually shot lower.
Mm-hmm.
And in this case, the tax they had some relief for, I think, this area. So the property taxes jumped far lower. So then we could show the disconnect between the original purchase price of the property and what the appraised values were at the time these gifts were made. So and they had this exact same response. So they just informed us a month ago that they're closing the audit, accepting the gift tax return is filed, and we're moving on. So interesting.
So we've been focused on the financial side of estate planning, and before we wrap up the show, I wanted to ask a question about, I guess what we could call it the non-financial side, things like healthcare directives, those kind of things. Again, I don't know, do the laws work the same way in the US and Canada? And I can imagine a situation where you've got, someone who's, traveling between the two countries, who knows where the person is going to be when, God forbid, he passes away. So how is that whole side of an estate plan? How do you deal with that?
Yeah, there's a lot of like non-financial issues like that. Normally, I would say the general approach, even on the financial side, but as well as the non-financial side, is usually whatever the country of residence is, as a general rule, is going to be home base.
Okay.
So if we have an English client and they reside primarily in England or domiciled in England, then the English estate planning lawyer is going to be the captain of the ship. And then our role is to make sure that our plans work well with that. And then absent an exceptional circumstance that's really, really bad in our country that I'm planning for, our focus is trying to make things very practical, very smooth after someone passes away, and then obviously minimizing the tax as much as possible without jeopardizing or causing any significant issues on the other side.
Right.
If there's for like healthcare directives and things like that, like each country is going to have their different legislation. Mm-hmm. So if there's an expectation that they will be moving countries quite a bit, then it's just a good idea to have those documents, which normally don't take much time to draft, to just have those ready in case the issue arises. So that would be my circumstance. It might not make sense if it's just if you're in that country for like 1 week a year.
Right.
But my view is you'd rather be safe than sorry on that on that issue. Spouses, spousal rights is a big issue. Your rights in different countries vary dramatically. So in California, there's a community property state that's fairly unique compared to other jurisdictions, and in Canada, spouses will have like in Ontario, Canada, they'll have like a set payment from the estate that they're entitled to, and in Ontario, a spouse when the surviving spouse has an option where they can elect to receive what they would receive on a divorce, or they can elect to receive what they inherit from the wills, from the estate. And so when you're planning for that, there's different options and remedies available in Ontario versus another state. We had a litigation case that was interesting. It was a new spouse. Their husband tragically passed away unexpectedly, and she's completely omitted from the California trust documents.
Oh, wow.
There's a question about whether she resided in Arizona. And so this estate, I think, was around like 36, 37 million. And in California, there's an omitted spouse doctrine, and in California, she receives half of everything.
Mm-hmm.
In Arizona, because the child was the main beneficiary, if the same circumstance happened in Arizona, I think there was only like 160,000 that she would receive. So that's a dramatic difference, and highlights the importance of updating the documents when your personal circumstances change, and how non-financial issues can play a massive role in how things are administered and what the outcome is.
Yeah. Wow.
Yeah, that's dramatic. That's like probably the most dramatic difference I think.
Yeah,
that I've
I
seen.
mean, it just it's mind blowing. And we were talking earlier about the U.S. and Canada sharing, kind of English common law as their basis. But of course, here in California, our state law is really based on Spanish law, which was very, very different than English law historically, right? So you've got that going on as well.
I've got a funny story about that. So when I first came down, I was working remotely for my Canadian firm while I was studying for the bar. So I was, going through the the bar books I purchased. And then I come up on the community property section. And I'm like, oh, that's interesting. They've got a whole section on what I thought was like law about parks and public land. Like, oh, community property. I also thought maybe it was about condos. And then after like 2-3 sentences in, I'm like, oh, this is family law. And so that's it's California. That was one of the aspects when I came down. I focused on, okay, I have to understand family law. I obviously have to understand the U.S. Constitution because there's different constitutions between the two countries. Right. But it's different.
Yes, thank you, Treaty of Guadalupe Hidalgo, right? Yeah. which is why we're a Spanish law based state. Well, Andrew, we could go on easily for another hour. There is so much here. So, with your permission, I'm going to have you on the show again very soon and climb through some more of these. But this has been just really fascinating, and I hope for the people who've been watching, and for those of you who watch, on YouTube, you get a sense as to just how complex these matters can be, and how important it is to deal with them, in advance while people are competent, and as Andrew was just saying a moment ago, to really keep up to date with changes in your life situation, changes in in the various laws as well. Here in the U.S., of course, we're all sort of hanging on to see what happens as to whether the 2017 Jobs Act will extend the current tax regime or not. We're already more than a third of the way through the year, and planning needs to be done, but there's not. There's no certainty. I know I talk to my clients about this pretty routinely, and honestly, I don't know what to tell people right now until there's some sense of what's going to happen. So Andrew, thank you so much for being on the show today. Really fantastic job. I'm going to have you sit tight for just a minute and take us offline, and then we can wrap up. So folks, if you have any, first of all, if you want to be in touch with Andrew, I will put his contact information in the show notes so you can get in touch with him. And like all my guests, I take it upon myself to make a shameless plug because they're too modest to do this. But you can see just the tremendous amount of knowledge and experience that Andrew has. So if you are dealing with these kind of cross-border issues, you absolutely can rely on Andrew to make sure that they are taken care of, not just competently, but absolutely as appropriately to your individual situation as is possible in this uncertain world in which we live. So I recommend Andrew to you unreservedly. Tomorrow at 10 a.m. Pacific time is my show, Business Lessons from the Military. And I'm going to be talking about from washed up to startup. For those of you who see behind me this particular picture right here, you may recognize Tim Allen in his role as Commander Taggart in Galaxy Quest. So I'm venturing a little bit out of the actual military world into the sort of fantasy military world, but thought we'd do something fun tomorrow. So we're going to talk about the lessons you can learn in business from the movie Galaxy Quest. And then on Wednesday at 10 a.m. Pacific time is my show my show People Making Money. And I'm going to be talking about the 5 best startup cities if you're thinking about launching a business. So the climate for startups varies tremendously from state to state, as do the laws that Andrew and I have been talking about. So tune in for that, and you'll get some thoughts on where is it best in the U.S. to launch a business. And then a week from today, we'll be back for the next edition of Trust and Estates Weekly. My guest is Shilpa Bhatt, and Shilpa is an estate planning and estate and trust attorney based in Orange County, California. And she's going to be talking about the importance of actually funding your trust. So, your lawyer goes through all the work of creating all this stuff, but if the assets don't get into it, it was all for naught. So please join me for what I'm sure will be another great conversation with Shilpa. So, Andrew, once again, thank you so much for being a guest today. Really appreciate it. For all of the people who joined us live viewing, thanks for being with us. Always a great treat to see you. And signing off as I always do. Marie, darling, you are my bell.